Good morning, everybody. Happy Sunday. I hope everybody's doing well and having a good weekend. My name is Jennifer Hamey with Jennifer L. Hamey, PA in Ellenton, Florida. I'm an attorney. If you've been watching before, you'll know that I've been doing some other videos, and I'm on video number 5. Today we're going to talk about bankruptcy under Hamey's Helpful Hints. This is a situation, an issue, legal issue that is always really difficult for people. It's embarrassing to a lot of people, and they just are like, oh, I don't want to bring this up or talk to anybody. But I will tell you, if you are facing any type of creditor issues, especially right now with a lot of people losing their jobs, losing their income either from one or two people in the household, feel free to reach out to an attorney. We're here to help you. We're not going to embarrass you. I've been doing this for almost 20 years. I love to help people. That's why I'm in my profession. And so I really want to be able to sit with you and see what we can do to ease the situation. It's stressful for the people's relationships. It's stressful medically, physically, mentally. And so if we can take this financial hardship off of you to make it that much easier for the rest of your areas of your life, then that's what we're here to do. So I just want to start out by telling you that. So if this is something that applies to you, feel free to listen to my information. If we can assist you in any way, if any attorney can assist you in any way, reach out to him or her to see what they can do for you. So when we talk about bankruptcy, there's two main bankruptcies that most people are going to fall into. It's going to be a Chapter 7 or a Chapter 11. And in a Chapter 7 bankruptcy, this is what we call a complete liquidation. So the debts that you have, we're going to put into the bankruptcy, and the court's going to say, okay, you qualify so that you can wipe this debt out, and then we're going to give you a discharge and you can move on your way. Gives you a clean slate, basically. But in order to do a Chapter 7, you have to qualify for a Chapter 7. And so there's a couple of things that they're going to look at when they're determining whether you qualify for a Chapter 7. And there's other exceptions that make it where you may not be able to do a Chapter 7, but I'm going to focus on the one that is what most people have to look at for filing. And so they're going to look at your income and they're going to look at your household size. So for example, say you have a husband and a wife and they have 3 children. So there's a household of 5. And each state is different with what their number is for household income that's acceptable, because each state has their own median income. But in Florida, for example, it's going to be around $90,000. Ohio is going to be similar. It's going to be around $90,000. So say you have this household of 5, husband and wife are both working. Their combined income is going to be around, say, $80,000. So they are going to qualify on that Chapter 7 just by looking at that income. Income allowance is $90,000. They're making $80,000. Court's going to say, okay, we're going to let you qualify for a Chapter 7 based on this income household size exception. So say that same couple has $110,000 in income. So same household size, husband, wife, 3 kids, household of 5. Income allowance was $90,000. And the court's going to say, okay, you're over the median income of what we think you should qualify for a Chapter 7. However, there's a second part to that test that can then be done that's going to go outside of just that gross number, and it's going to look at things like your taxes that you pay, your health insurance, car payments, house payment, things like that we're going to be able to deduct out. And when that calculation is done after deducting out those things that are allowed, at that point, then there may be a negative number and that couple may still qualify for a Chapter 7. So that's going to be something that gets looked at to determine if you're going to be eligible for filing a Chapter 7. You're always going to want to get with an attorney that knows bankruptcy well, because that can be a complicated determination, and you want to make sure that the attorney you're working with knows exactly what they're doing in those calculations to make sure you get put into the correct bankruptcy. Now, if you don't qualify for a Chapter 7, all is not lost. There is still a second option for you, which is a Chapter 13. Chapter 13 is what's called a repayment plan. And what's going to happen is you're going to be in a repayment plan for the period of 3 years to 5 years, depending on where that qualification falls into. And they are going to involve 60 months of pay, so we'll say 5 years, 60 months of payments, where you're making one payment every month to the trustee of your bankruptcy, and they're going to divvy that among your creditors. Now, why that is still beneficial for you is a few reasons. So even if you don't qualify for a Chapter 7, take a look at what you're paying every month on your credit cards, for example. Say you have 5 credit cards, and between the 5 credit cards, you're servicing $1,000 a month in minimum payments, and you're on that hamster wheel. I call it a hamster wheel because it's you're paying off the minimums every month just so you can use the card again for food and gas or whatever you need, and you're on this hamster wheel that you're never going to get off because it's going back and forth the same every single month. So say those payments total around $1,000 a month. Now, when we do the bankruptcy calculation, even though you don't qualify for the Chapter 7, it may say, okay, based on your income and expenses and what's available, you have $300 a month that you can pay into your plan. So we're going to require you to pay $300 a month into your plan. So it's good for several reasons. One, your $1,000 worth of payments went down to $300. Second, at the end of that 5 years, regardless of whether you've paid back 100% to your creditors or not, you're going to get your discharge and you're not going to owe anymore. It's going to stop late fees. It's going to stop judgments. It's going to stop any type of garnishments. Creditors have to file claims. If they don't file a claim, they don't get paid. So it is still beneficial to you if you can reduce what that monthly output is in your expenses on your creditors and can instead just make one payment every single month in a plan. So that's a second option for you as well. And I will say that I don't do Chapter 11s. Those are business bankruptcy filings. And you'll see, people have heard about those in the news. It's going to be a situation where you've got GM or Toys R Us recently did it. I think Frontier's getting ready to file. And those are big businesses that are trying to stay in business, but they need some reorganization assistance because they're out of money. But the law has just changed in February of this year, actually, and they now have what's called a Subchapter 5, and that is a Chapter 11 bankruptcy for businesses that are designed for small businesses that are still wanting to stay in business, but they need some assistance, some reorganization. So if you are a small business, especially during this time period with everything that's happening, if you are a small business and for some reason you do need that assistance, seek counsel from a Chapter 11 attorney who can help you with that, because that might be something that's beneficial for you. Okay, so those are the types of bankruptcies that you're normally going to see. So next we have paperwork. What kind of paperwork do you need to gather for the attorney if you're going to be seeking bankruptcy? Now, most bankruptcy attorneys have their own form, their own list that they're going to give you saying, hey, I need items 1 through 10. But if you want to start gathering those types of things together, because you know this is something you're going to be considering, start putting together things like the last 2 years of tax returns, last 6 months of pay stubs, last 3 months of bank statements, titles, registration for cars, a list of household goods, any art, jewelry, anything of value we'll need to know about. If you had a divorce in the last 4 years, we're going to want to see the divorce decree, any contracts you have with anybody. So those are things you're going to want to start getting together if you want to start putting paperwork together to be organized for meeting with an attorney on this matter. One of the questions that I get a lot of is, am I going to lose my house? Am I going to lose my car? These are assets that I want to keep. The simple answer to that is no, not generally. But of course, there are always exceptions with that. So, person has a house, person has a car. If you owe on that car and that house and you want to keep it, you can keep making payments on it. Mostly you're not going to lose it depending on the equity, which I'll talk about in just a second. But you have to keep making the payments on the house and the car. This is not a situation where you say, okay, I want to file bankruptcy. I want to get rid of all this debt, but I want to be able to keep these assets. Because if everybody could do that, we'd all go buy houses and then file bankruptcy and then never have to pay them back. So it doesn't work that way. You do have to keep making the payment on the house or the car that you wish to keep. Now, you may be able to work a loan modification out with the company to get a lesser payment or a longer term or lower your interest rate if you're struggling. Those are options that you have, but you do have to make the payment. Now, when it comes to things like RVs, recreational vehicles, boats, which is a big one down here in Florida, motorcycles, things like that that are not necessities, the court's going to not be so keen on you keeping those types of things. The court's not going to want to hear that you want to file bankruptcy on something that's happening in your life because you can't afford these things, but I want to keep my $800 a month boat payment. So that's, you have to be in a position where you're going to be willing to turn those types of things in, because oftentimes you're not going to be able to keep those items, or there might be some contesting happening with those items. Now, each state is different. I'm just speaking to Ohio and Florida, the states that I practice in, that I know the trustees are going to be questioning those types of things. Now, as it relates to your house and your car, like I said, you have to keep making the payments, but they also need to look at the equity in it. So if you have too much in equity, depending again on the state, you may be risking losing those items. Now in Florida, Florida's very big on the homestead. So in Florida, you can have, as long as you've lived in the state for at least 4 years, and there's a couple other exceptions, you are going to keep your house whether it's got $1 million in equity, $5 million in equity, 50,000 in equity. Here in Florida, they say you can keep it. In Ohio, it's a lot less. You can only have, for a couple, if a husband and wife own a house together, it's going to be about 250,000 in equity you can have. But honestly, I can tell you that in all of the years I've been doing it, I very, very rarely have ever seen anybody who's filing bankruptcy have more than $200,000 in equity in their home. So it's not a question that comes up very, very much. So as long as that equity is not an issue, and again, when you speak with an attorney, they'll run values on your cars and your houses, and they'll determine if there's going to be any issue there before you file. Now, along with that is exemptions as a whole. So each state, again, has different exemptions that they provide you based on the state. So the state can either choose to use the federal exemptions, or they can use their own state exemptions. Most states, I think, have opted out of the federal exemptions, and they use ones that are specific for the state. Now in Florida, that's not such great news. In Ohio, it's pretty good news. I used to think in Ohio that the exemptions were low, but they're actually not that low. Now that I practice here in Florida, I see that they are not actually that bad. So in Ohio, things like, for example, a car. Say you have a 2001 Honda Accord. You do a Kelley Blue Book value on it, or a NADA value on it, and you determine that the car is worth $4,000. In Ohio, you have a $4,000 exemption. So in Ohio, they're going to let you keep that. Even though you have $4,000 in equity in your car, the law says that is exempt. That's an acceptable amount for a vehicle, and we're going to let you keep it. Now, in Florida, it's not going to work that way. In Florida, if you have a car and it's worth $4,000, the exemption down here for a car is only $1,000. So the court is going to say, the trustee is going to say, yes, you can keep that car. We'll take off the $1,000 exemption you're provided, but you're going to have to pay in $3,000 if you want to keep that equity in that car. So each state, like I said, is different on how that's handled, and when you meet with an attorney, they'll go over all of those things with you as to what type of scenario you're going to be looking at. And then they have exemptions for jewelry, household property, things like that in each of the different states. Some exemptions are federal that apply to all of the states that are not going to be touched. Things like IRAs, 401ks, ERISA plans, those types of things are generally protected money. And as a side note to that, before you think about clearing out your 401k or your IRA to pay off creditors, I would suggest talking with somebody about your options, because that's protected money. That's money that no matter whether a creditor gets judgment or not, they're not going to be able to reach in there and take that money away. They're not going to be able to get a judgment and then contact your employer and say, hey, employer, this person owes me $10,000. I have a judgment. I need you to grab that 10 grand out of their 401k and send it to us to pay us, because the law doesn't allow for that. So before you start clearing those monies out, I would suggest talking to somebody to see if there's better options for you. I always feel so bad when somebody comes in and says, I've liquidated my 401k and I'm still in this position because I still wasn't able to pay off these things. And I was like, oh, I would have told you not to touch that money. But so that's just a side note of something that you may want to look at before you think about clearing those monies out. Okay. So I have some information here that I got from an attorney friend of mine. Her name is Christy Arkovich. And she is an attorney in Tampa, and she does some really good blogs. She knows a ton about student loans when it comes to student loans and bankruptcy. She's a bankruptcy attorney. And so I always pick her brain for things. And if you have any weird student loan issues or things that you're concerned about, whether they're giving you the debt forgiveness they're supposed to give you if you're a public employee, or if you are concerned about who's holding your student loan, or if they're collecting the way they're supposed to be collecting, I highly suggest contacting her, because she's tried a lot of cases at a lot of different levels. They've been very successful in some of the suits that they've brought forward of holding the lenders accountable for some things. So that may be something you want to reach out to her. Again, she's in Tampa. Her name is Christy Arkovich, and she can assist you. But she did this blog, and I asked her if I could share it with you guys, and she said, sure, no problem. And so I am going to share this with you, and I'm just going to give you some bits and pieces about it. It is on her website if you want to check out the whole thing. But basically it talks about debt collection, especially during the COVID-19 issue. So we all know that debt collectors, they'll call you, they'll hound you. A lot of people think, oh, I owe the debt, so I just have to deal with them contacting me. But that's not the case. You don't have to deal with that because there are Fair Debt Collection Act requirements that they have to conform to when they're reaching out to you to try and collect the debt. And right now during COVID-19, there are especially some things to look for. So one of the things that she pointed out was if you have been directly affected by COVID-19, like you've had a loss in income or a reduction in income, and you've notified that collection agency or that collection creditor when they call you that, hey, I've been directly affected by COVID-19, they're not to be contacting you anymore. So if people keep contacting you after you've advised them of these things that I'm going over, keep a log of the date that they called, who called, if you can get the name of who you talked to, what creditor they represent, and keep track of that because you may have a case in the future against some of these creditors for violating the Fair Debt Collection Act. And alternatively, if you do end up filing bankruptcy, the trustee wants to know this information as well. So they want to know if people continue to call you after you told them this information and if they continue to call you after the bankruptcy. So keep a log of that. They are not permitted to collect from anybody who has a state that's been declared a national emergency. And newsflash right now, every state in the United States has been declared a national emergency because of COVID-19. So nobody should be calling at this point. Also, if they're collecting from people who have lost their jobs, been furloughed, or laid off, again, if you notify them of this information, they need to stop contacting you. And also, this is not in this documentation, I just happen to know this information. If they're calling you at work and that's not permitted and you advise them to stop calling you at work, or you can advise them to stop calling you, period. Say, hey, I just want your correspondence in writing. They have to stop calling you. So if they're not doing that, then again, make sure you're keeping that notes. And then back to this documentation as well, collection employees who are collecting from home. So, a lot of employees are working from home. They're like, oh, I'll do my collection efforts at my house. They're using their own personal cell phone or their own personal landline. They're not in a protected privacy area. That could be violating your rights because your private information is out for other people to be able to get access to. Social security numbers, date of birth, addresses, names, phone numbers, those types of things. So watch out for those kinds of things. That's just a side note. I thought it was really good information that I saw she had posted, so I wanted to share that with you guys. So thank you, Christy, for that. Okay, dischargeability. At the end of the day, I want to get my discharge. I want to get an order saying, hey, I no longer owe this money. I'm done. So in looking at the discharge, you will get that at the end, of course, when the bankruptcy is all over. And what type of things are going to be dischargeable? So pretty much most things are going to be dischargeable. Your credit cards, payday advances, overdrawn bank account, medical bills, personal loans that aren't secured with anything, outstanding utility bills. Those types of things can all be discharged, will all be discharged. Things that are usually not discharged are going to be things like student loans, taxes. But of course, there's exceptions to those as well. There's hardship exceptions for student loans, and like I said, if you think you fall under that, Christy is definitely a good person to hit up for that if you're in the Tampa area. So look into whether one of those may apply that you may need to file for. Taxes, again, there's going to be some exceptions if you filed within the last if you filed timely and it's been longer than 3 years, you may be eligible for some relief of discharge on some of those as well. So those may be some exceptions. Again, if you talk to a bankruptcy attorney, they can go over that information with you. Now, the final topic I want to talk about under bankruptcy is your credit report. So I get a lot of questions of people who are like, oh my gosh, my credit's going to be just absolutely destroyed if I file this bankruptcy. Unfortunately, I got a newsflash for you. Oftentimes people have that problem already, that their credit is destroyed by the fact that they're not paying their bills. So things like late pays, skipped payments, collection agencies showing up on your credit, your debt to income ratio, your debt exceeds a lot more than what your income can support. Those types of things are all hitting your credit negatively. So when you file a bankruptcy, Chapter 7 is going to stay on your credit report for up to 10 years. Chapter 13 is going to stay on there for about 7 years. But most people are going to just see an effect for about the first year and a half to 2 years as far as it being kind of negative against them. Now, what I do at my office, and I know other attorneys do this as well, is I have a program through my Best Case, which is my bankruptcy program, that allows me to pull a credit report from all 3 reporting agencies that will show a current credit score, as well as what a person can anticipate their credit score to be about 15 months post-bankruptcy. And I'd say 90% of my clients see an increase of about 50 to 100 points within about 2 years of filing their bankruptcy. So it's not going to affect you for that 10 years or for that 7 years. And the longer that time goes by, the less and less that bankruptcy affects you. The only time I've really seen it affect longer than 2 years is if a person has a foreclosure on their record. So they lost their house, it went through a foreclosure. In that circumstance, I will see banks and mortgage companies say, okay, we're going to wait a little longer before we'll give you a loan because you have a previous one. And even in that circumstance, it's usually about the 2 to 3 year mark that I see that happening. And then there will be places like car companies, credit cards, that you'll get notification for after you file the bankruptcy saying, hey, let us help you rebuild your credit. And an attorney can help you in setting up how you should be helping to rebuild your credit. So those are really the things that are important, I think, to point out for anybody that may be considering bankruptcy. So I hope that this was helpful to you in my helpful hints. And so moving forward, a couple things. I hope to have my office, or I am going to be starting to do in-person meetings again, consults again, effective May 7th, because I think we're getting to the point where that might be okay. And I'm going to be really cleaning down my office after each appointment and just trying to only keep it to maybe 2 or 3 a day so that I don't have a ton of traffic coming in. And I think, I can't speak for other people, but I think a lot of, from what I'm seeing, is going to be taking place. So, but if you have any questions, as always, feel free to reach out to me on Facebook, YouTube. You can look on my website. I have information on there. It's www.jenniferhameypa.com. You can contact me on my email address, which is jenniferhamey@gmail.com. You can call 941-932-6217 if you want to get any information. Next week, I do have some fun things going on for some appointments. As an attorney, I don't know all the law of all the different areas. So I do have a guest coming next week. I'm not quite sure. I think we're tentatively scheduled for Wednesday to make that video. So that's going to go over domestic relations things, which unfortunately, because of COVID-19, we are seeing a spike in possible divorces, people separating. So that may be an area of interest. And then I also gathered some information regarding planning for when you pass away, some different avenues and options that you have for setting up for when you pass away. So those are 2 that I know I have on the horizon for next week. There may be more. But as always, I hope everybody has a great weekend, a great Sunday, great next week. The sun's finally back out here in Florida. It's been a little rainy over the last couple days, but seems pretty good today. And we'll talk with you soon. Have a great day, and goodbye. Bye.